Okay, welcome everyone. On behalf of Osgoode Hall Law School and IP Osgoode, thank you so much for joining us today at this very exciting event, which is part of the IP Osgoode Speaker Series. Now, I'm Professor Giuseppina D'Agostino, and I am the founder and director of IP Osgoode. IP Osgoode is the law school's flagship IP and technology program, and if you haven't been on the website already, I do encourage you to visit iposgoode.ca, which contains all that is new and exciting in IP here in Canada and around the world. And I should mention that on the website, we will be posting a recorded version of this session that will be made available at a later date. And the conversation continues, because as many of you know, we have a blog, the Ipilog, and one of our Ipilog editors, Adam Del Gobbo, will be blogging on today's event. So I do encourage you to check out the website. Now, today's event is possible because of the generous support of some of our founding law firm and industry partners. And here I'd like to acknowledge the Canadian Copyright Collective, the Audiovisual Licensing Agency, and our 5 law firm sponsors. So a big thanks to Castles, Gowlings, McCarthy's, Norton Rose, and Oslers. So thank you very much. Also, I have to say that events like this don't happen without a lot of logistical support. And here, I'd like to take the opportunity to welcome the newest addition to the IP Osgoode team, and that's Michelle Lee, right there in the corner. So Michelle joins us with her enthusiasm and capabilities as the IP Osgoode coordinator. And she's been helped also by Mary Barbieri, who is our admin assistant, so we've been in good hands, so thank you very much. Now, we've actually never hosted an event where as soon as we posted the event that was sent through the Ipigram, we received a flurry of RSVPs almost instantly. And I have to say, that says a lot about the nature of this event. Also, we've hosted a lot of events since 2008, which was when IP Osgoode was born. So again, revelatory of what we have today in store for you. And I might add, by many members of, respectable members of the IP community. So just look around you in the audience, right? Now, our distinguished guest will be introduced momentarily by Professor David Baver, but I want to underscore that this event is also possible because IP Osgoode really aims to inject many new voices to the IP debate and really intensify the learning opportunities for our students and the wider IP community, both here in Canada and around the world. And today's is no exception. In fact, since the Supreme Court of Canada handed down these 5 hot decisions this past summer, which sent abuzz many circles, I know in the academic circle and beyond. Just outside we were talking about different titles of our papers to the decisions. Really what we have today is a privileged occasion to hear directly from the leading architect of some very strong dissent among 2 of those decisions. So we're very, very honored today. And here, the way we have the next hour and a half set up is that we have allotted about 45 minutes of talk time to our distinguished guests, and the remaining time is a portion to a moderated discussion. So that's your chance to ask your questions. So it is now my distinct pleasure to ask my colleague, Professor David Baver, to introduce to you the Honorable Mr. Justice Marshall Rothstein of the Supreme Court of Canada.
Thank you, Professor D'Agostino, and welcome. I'm delighted to be able to introduce to you Mr. Justice Marshall Rothstein of the Supreme Court, who will be talking to you today about his reflections on the 5 copyright cases that the Supreme Court of Canada decided earlier this year. Many of you will know Justice Rothstein from the many judgments he's delivered across all areas of the law in both the Federal Court and the Court of Appeal, and of course in the Supreme Court of Canada since he commenced sitting there 6 years ago. I'll nevertheless say just a few introductory words about Justice Rothstein and the subject of copyright. I don't want to eat too much into his 45 minutes, but I think some of this may be of interest. Anyway, before becoming a judge, Justice Rothstein practiced largely in transportation and administrative law, as well as also being a human rights adjudicator in both Manitoba, his home province, and in the Canadian Human Rights Tribunal. So over his 26 years of private practice, he also served on a number of provincial and federal commissions, boards and committees dealing with transportation as well as legal aid and compulsory retirement. If you want a much fuller summary of those matters than I'm going to give you, you can look on the Supreme Court's website where you will not only see that, but you'll see Justice Rothstein in full regalia, which is something which looks, which as we approach Christmas, you'll recognize. Justice Rothstein developed a major interest in intellectual property law after being appointed to the federal court in 1992, and has, as you know, written a number of quite influential judgments in the field of intellectual property over the 20 years that he's served as a judge in the trial division in the Federal Court of Appeal and now in the Supreme Court of Canada. On his appointment to the Supreme Court in 2006, I don't think he would have predicted that he was going to be one of the court's central figures in copyright cases, but it was predestined. The date of the official ceremony at the court welcoming him as a new member was April the 10th, 2006, which of course, as copyright mavens know, is a very significant day in copyright history, as the date on which England enacted what is regarded as the world's first copyright law nearly 3 centuries ago. So April the 10th, 2006 celebrated both the advent of a new justice of the Supreme Court of Canada and also the 296th anniversary of the Literary Copyright Act of 1710, also called the Statute of Anne, apparently because no other statute during Anne's time was worth mentioning. The significance of that date became apparent to the Justice very early on, because one of the first matters with which he had to deal with was a case the Supreme Court had reserved and on which they were deadlocked when he came to the court. They were deadlocked 4-4. So it was a class action brought on behalf of freelance writers who were complaining that newspapers were digitizing their articles and putting them online and on CDs without their consent and in breach of their copyright. With the parties' consent, Justice Rothstein read the factums, watched a recording of the oral argument before the court, and cast the vote that broke the deadlock in the case called Robertson against Thompson Corporation. Some commentators like neither of the majority nor the minority judgments, and some wish that Justice Rothstein had written a concurring judgment, putting them both straight. But I guess if there's one way permanently to alienate all of one's colleagues on a court as a new judge, it's to write a judgment saying that all 8 of them are wrong, and here is what they all missed. So one can understand why the new justice simply chose one result over another and cast his vote accordingly. We like to think that copyright involves all this new high-tech gadgetry, and we forget that it also covers some pretty low-tech stuff like chocolate bars. And so it proved, as the Kraft Company came to the Supreme Court saying that it could use copyright to stop parallel imports of its Toblerone chocolate from Europe to Canada. It lost in grand style, but the court split 4-3-2, with Justice Rothstein delivering judgment for a plurality of 4 judges. This is one of those cases where it's hard to figure out if there's actually a ratio, because apart from a 7-2 majority against Kraft, the only other thing the 3 groups of judges agreed on was that they disagreed with everything each other group said. So that gives you an idea of the sort of copyright law in Canada we have and the difficulties of interpretation that it gives rise to. But nothing daunts the Supreme Court in general, or Justice Rothstein in particular, so it was with great anticipation that IP lawyers saw the court give leave last year to 5 decisions of the Copyright Board, ranging from whether record companies could get money each time a movie played the soundtrack when exhibited, to whether teachers could make photocopies from textbooks for their students, and to whether the Canadian Performing Rights Society could charge for music downloads and streaming and clips from music made available by online sellers like iTunes. The Copyright Board came out about even. It won 2.5 of its cases and lost 2.5. The case raised fundamental issues of copyright law, and the court was unanimous in 2 cases in which Justice Rothstein joined in the court's opinion. He wrote judgments in 3 of the other cases, 1 for an 8-1 majority, and 2 in which he wrote dissents for a 4-person minority, both cases where he would have, and the minority would have preferred to uphold the board's decision rather than reverse it as the majority wanted. As Professor D'Agostino said, there have been, since the cases were handed down on July the 12th, a plethora of conferences, colloquies, papers dealing with those cases, and the stream hasn't as yet finished. So it is our privilege today to hear from the judge who was so closely involved and influential in them all. Welcome, Justice Rothstein.
Well, thank you, David, for those undeservedly generous remarks. It's quite a contrast from what some other people say. A while ago, I left home and went to the office. My wife Sheila asked me to remove the bed linen for washing that day, which I thought I had done before I left. Email, Sheila Rothstein to Justice Rothstein, 10:53 a.m. I told you to remove all the linen, including a blanket cover. You did not listen to my instructions and only did half a job. I hope you do your legal opinions better than removal of linen from a bed. When you get home, you will make the bed all by yourself. Washing all the linen and pillows is enough of a job for me. We need fluff for the dryer and pads for the Swiffer. That's the floor mop. The length should be as long as possible, 8 to 12 inches. 12 is preferable, but I'll accept shorter if they don't have 12. We need Kraft cheese, fat-free. Fruit, egg whites, and peanuts. Get the peanuts that don't have that god-awful brown covering over them. What's wrong with shelled naked peanuts? Why do you buy gross peanuts? Time to wake up and smarten up. I'm sure glad you didn't ask Sheila to introduce me this morning. Well, I know that David and Pina were kind of disappointed that I didn't come galed out in my red Santa Claus robes today, but it was too heavy to bring on the plane. And I didn't know that the date of my swearing in was as auspicious as David has encountered to you. I was actually born on December 25th, which was what I thought was a pretty auspicious day, at least for some people. But now I've got 2 of them. And David mentioned the Kraft case. All the Kraft case tells you is that everybody at the Supreme Court thinks they're an expert in copyright. Well, I have to say that being introduced by David is a great honor. It's no exaggeration to say that he is one of a very few icons in the intellectual property community in the world. His introducing me brings to mind the story of the Pope. he had an engagement. So he came down to the car that was waiting for him, and he decided he wanted to drive. So he told the chauffeur to get in the back seat, and he got in and started driving. Unfortunately, he was going too fast and he was stopped. The officer came to the car window. When he saw the Pope, he decided he had better call headquarters. Called headquarters. He said, "We have an incident here." Desk sergeant said, "What's the problem?" The officer said, "Well, I've stopped someone really important for speeding." Desk sergeant said, "Who is he?" Officer replied, "I'm not sure, but the Pope is his chauffeur." Today, I feel like the guy sitting in the back seat with the Pope as my chauffeur. So my topic today is what has come to be known as the pentalogy. My computer didn't recognize that word, neither did my Oxford Dictionary. I figured it must be one of those technical IP words that have meaning to IP lawyers but not to people. But before I say more about these cases, I'll tell you that if anyone walks away today thinking that I've said anything different than any of the cases in the pentalogy say, you will be mistaken. And if you aren't, you'll still be mistaken. And if anyone seeks to use what I am saying today before any court or tribunal about those cases different from what the cases actually said, I will find out who you are. Well, today I'm going to be talking a little bit about these cases where our judges have been disagreeing with each other. So I'm going to have to be very careful. Like the story of the farmer in the Old West. His wife died, they loaded her onto the wagon, and they put her in the casket, loaded her onto the wagon, and they went to the cemetery. On the way to the cemetery, they hit a hole in the road. The casket popped open, the wife revived, and they went back home. After another year, she died again. They put her in the casket, loaded her on the wagon, went down the road. When they came to the place where the hole in the road was, the farmer said, "Now this is where we really have to be careful." I'm going to have to be really careful today. Well, with that, I'll start with resound, and I'll be very brief on resound. You'll remember that resound was about whether performers and owners of sound recordings were entitled to payment when their performances and recordings are incorporated into the soundtrack of audio-visual works like movies and TV shows, and those works are performed in public. And our court found, based on definitions in the Copyright Act, that a pre-existing sound recording is part of a soundtrack and cannot be subject to a separate tariff and charge when the soundtrack accompanies a cinematographic work. And to us, at least, the case wasn't controversial, and I won't say more about that case. Socan v. Bell was about online previews of musical works that consumers listened to before purchasing the work. The issue was whether listening to these previews constituted research for the purpose of fair dealing under the Copyright Act. The analysis adopted in the seminal CCH versus Law Society case, the template there, first to determine whether the use or dealing was for an allowable fair dealing purpose, and second, whether the dealing was fair. That was the template that was followed. And we had no difficulty finding that the previews did constitute research and allowable fair dealing purpose. And we also had no difficulty finding that the Copyrights Board analysis of the fairness of the dealing was reasonable. Accordingly, royalties would not be payable to the copyright holder, and Socan's appeal was unanimously dismissed. Well, there are I thought maybe four interesting things about Socan v. Bell that I might mention. Perhaps they're obvious, but anyway, one is that research is confirmed to be a very low hurdle to overcome. Research need not be in a laboratory or a university. It may be for commercial purposes, as in the case of previews for the purpose of selling online copyrighted material. So this is a rather expansive approach to the first CCH test. Second, the second CCH test is the dealing fair, is to be looked at more closely by the Copyright Board. The fairness analysis requires balance. It should be a factual determination, so reviewing courts will have to give deference to the decisions at first instance, or at least they should. And I'll come back to that later when I speak about the access copyright case. The third is that fair dealing is to be assessed in the circumstances between an online vendor and purchaser from the point of view of the purchaser or the user. So it was the user's research purpose and not the vendor's sales initiative that was determinative in that case. And again, I'll come back to the question of whose purpose is determinative when I get to the access copyright case. The fourth, and maybe it's a duplication of the first point that I just made, is that research needn't be associated with traditional intellectual pursuits, whether that be research in a lab or research in a library or research indeed in a lawyer's office. It can be for strictly entertainment purposes. Well, it seemed to us that there were limitations on the nature of the preview, such as low quality, limited time in relation to the length of the whole work, the fact that it was streamed and deleted when it was completed, so that they would not duplicate and compete in any serious way with the actual purchase of the musical work online. The Copyright Board had found that previews constituted research and the dealing was fair, and we upheld their decision as being reasonable. Now, Rogers v. SOCAN. I'll just spend a little more time here. I don't know whether this is obvious or not, but if you've read the decision, you might wonder what all the fuss was about. All the court decided was that streaming of a song to an individual user who requested the stream from an online music service was a communication to the public under Section 3(1)(f) of the Copyright Act, even though there was only one originating point and one recipient at a time. So the stream was protected by copyright, and the copyright owner was entitled to collect a fee for the stream over the internet under Section 3(1)(f). At the time Rogers came before the court, there was a lot at stake. The authors, artists, and music publishers were arguing that every stream and every download of their work infringed on their communication right. And they had won that argument before the Copyright Board and the Federal Court of Appeal. Well, the interpretation of communication to the public dealt with in Rogers would have been a much bigger issue if it were not for another case that we decided, Entertainment Software Association versus SOCAN, which I'll refer to as ESA. ESA in some ways took the wind out of the sails of the copyright holders' arguments in Rogers, because in ESA, the court decided that downloads were not communications under the Copyright Act. Because downloads were not communications, whether they were to the public, and I think they would have been to the public under Rogers, was moot. Well, more on ESA in a few minutes. But in Rogers, the court unanimously agreed that streaming was communication. And the issue was whether streaming was to the public, and that really wasn't very controversial. If you looked at it from the recipient's position, you would say he or she was receiving an individual transmission, not one to the public. If you looked at it from the sender's position, you might conclude the opposite, because the sender was issuing or intending to issue multiple transmissions. Well, technological neutrality kept into this decision. I'll talk more about technological neutrality when I get to the ESA case, but for now, let me just make the point that by using the term communicate to the public by telecommunication in Section 3.1f, Parliament was recognizing new technologies and that copyright protection should not be determined by the form of the technology used to perform that communication. So whether the technology was traditional push-type radio or television broadcasting, or pull-type technology where the communication is initiated by the consumer, should make no difference. Here, the copyrighted work that is streamed online is made available to an aggregation of individuals of the general public, so communication is to the public. Now, I'll turn to one of the two more controversial cases within the pentalogy, ESA v. SOCAN. I'll start with a story that I admit is a little bit self-serving, but having come second in ESA, you'll eventually understand why I'm telling you this story. As David told you, before I was appointed to the federal court in 1992, my legal practice was essentially in transportation and competition law, or administrative law. In 1990, I represented the four western provinces against the railway companies in a case involving freight rates on grain. Unlike other commodities, where rates were generally set by market forces, grain rates in Western Canada were regulated based on calculated railway costs. And there were formulas built into the Western Grain Transportation Act under which the railway's compensation for carrying grain was to be calculated and worked back into the freight rates paid ultimately by the grain producers. Well, the case involved a claim by the railway companies that they were entitled to an additional $160 million for a certain period of time under a formula in the legislation. The four provinces, on behalf of the grain producers in Western Canada, were of the view that the formula in the legislation should not be interpreted to grant the $160 million to the railway companies. So that's what the dispute was about. I had been successful before the Transportation Tribunal, and the railway companies had appealed to the Federal Court of Appeal. For the appeal, they retained a lawyer who some of you may have heard of, Ian Binney. Well, I read his appellant's factum, and I didn't think it said anything too startling. I prepared my respondent's factum, and the case was set down for hearing in Calgary. The case was to start in the afternoon and go over to the next morning if necessary. Well, Ian's oral argument on statutory interpretation in the afternoon was absolutely compelling. I can't remember now whether he departed from his factum or whether he just articulated its points in a particularly persuasive way that I had not perceived when I had read the factum. He was finished close to 5 o'clock, and so we adjourned until the next morning. Well, when I came out of court, I was shell-shocked. I hadn't really come to grips with the statutory interpretation argument that he gave an oral argument. I had a young junior with me, and we hurried back to the hotel and started to try to unravel his oral argument and try to figure out how we could answer it. We didn't go for dinner. At midnight, my junior said to me, "Can we order up some food from room service?" I told her, yeah, she could, but this is over 20 years ago, and there was no overnight room service at the time. 2:30 in the morning, she said to me, "This is rather unpleasant." Today, she's a highly successful and respected tax practitioner at my former firm in Winnipeg. She's not a litigator. In any event, we went on the next morning, and I presented our argument, and it was about statutory interpretation. But the thrust of the argument was that the railway companies were double dipping. That was the effect of their interpretation of the statute, double dipping. If they got $160 million that they were after, they would be compensated twice for the same costs. And lo and behold, the Federal Court of Appeal agreed with me, and I was successful. But I will tell you that Ian Binney was probably one of the toughest, if not the toughest opponent I ever had in my practice. But my point is this: judges don't like double dipping. And if they think someone is double dipping, they will go into contortions to preclude it. Well, let me come back to ESA. The issue in ESA was whether a copyright owner's communication rights, in addition to his reproduction rights, are implicated when a consumer downloads a purchased copy of a video game that contains the copyright owner's work. And I'll talk a little bit about that. But the point of my practice story is that it really may not matter how strong your statutory interpretation argument may be. If your interpretation results in allowing double dipping, the courts will strive mightily to find against you. Well, I don't say that that they do so in any unprincipled way. The judges may well conclude that in the case of legislation that may be subject to interpretation, and what legislation isn't, they will choose an interpretation that doesn't result in double dipping. But it's still a question of statutory interpretation, and sometimes you can't get around the words in the statute. So ESA, the case was whether downloading a video game that included a copyrighted song engaged Section 3(1)(f) of the Copyright Act as a communication to the public by telecommunication. If it did, the copyright owners would be entitled to compensation for that communication, in addition to any compensation which may have been payable for the reproduction of the work. Well, there were statutory interpretation arguments on both sides in ESA, but ESA had the important trump card going its way, double dipping. The statutory interpretation argument centered on Section 3(1)(f) of the Copyright Act, and in particular, whether the words "to communicate to the public by telecommunication" applied to downloads over the internet. In Rogers v. SOCAN, the court was unanimous that these words did cover streaming, but we came apart when it came to downloads. One of the journalists who wrote about the decision after he read it said, and I quote, "The legal word fight is mind-numbing." He was right. I'm going to try to avoid numbing your mind today. As I read their judgment, to the majority, it was the principle or objective of technological neutrality that was controlling. Downloads were copying. That was already covered by the copyright over reproduction and the royalties that were collected for copyright owners for that reproduction. If you purchased a disc or a CD at a commercial store, there would only be one royalty collected for reproduction. Technological neutrality demanded that there be only one royalty collected if copying was done by downloading. So fundamental to the majority was characterizing downloads as reproduction and not communication. As for statutory interpretation, the majority found that downloading was a form of copying and already covered under the exclusive right of reproduction. So they dismissed recent Supreme Court immediate precedent saying downloading was communication as being either obiter or just wrong or both. One of the fundamental statutory interpretation points in the majority judgment is found at the very end of the reasons, their reasons. If you look at the preamble to Section 3(1) of the Act, and I see that it's up here, you'll see that it says that copyright means the sole right to produce, reproduce, perform, or publish a work. And the preamble ends with the words, and includes the sole right. And then follow 9, if I've counted correctly, and with the new bill C11, 10 enumerated rights. In the view of the majority, the list of rights is simply illustrative of the sole rights to produce, reproduce, perform, or publish a work set out in the preamble. And this, of course, supported their position that the communication right in Section 3.1f was just a form of the performance right in the preamble, and that a download is akin to a reproduction and not a performance. Well, this is quite a profound, I think it's quite a new and profound interpretation of Section 3.1 in the definition of copyright. I think traditionally the enumerated rights were seen as additional or self-standing rights on their own. It appears that when Parliament saw a new circumstance that it considered should be entitled to copyright, it added it to Section 3.1. Well, did it do so simply to add certainty to the basic rights in the preamble of production, reproduction, performance, or publication? Or was that in their mind at all? Perhaps Parliament was legislating pragmatically to cover new situations and didn't care if they were related to a basic right or not. In any event, as a result of ESA, it would appear that they are to be, all these listed rights are to be subsumed in the basic rights to produce, reproduce, publish, or perform. Well, I'll take the liberty of suggesting that from the majority reasons, it was technological neutrality and double dipping that were the primary reasons for their decision. But I'm not suggesting devoid of an arguable but brief statutory interpretation analysis. Now the dissent. Well, my words may sound a little defensive, or maybe a lot defensive. I thought I had gotten over the loss, but when I came to prepare this presentation, I realized that I hadn't. Well, at least this will give me an opportunity to get it off my chest. In a nutshell, to the dissent, the decision was strictly one of statutory interpretation. Copyright is a creature of statute. The statute creates a bundle of independent statutory rights. The job of the court is only to give effect to those rights. While the Copyright Act provides for a balance between owners' and users' interests and rights, the court must always respect the language chosen by Parliament and not override it. The dissent recognized that technological neutrality was a desirable objective, but it was not a statutory requirement, such as to overrule the language of the Act and divest copyright holders of their statutory exclusive rights. The dissent first looked at the ordinary meaning of the word communicate in Section 3.1f and found that the word meant to convey or transmit, amongst other meanings. And indeed, in SOCAN versus Canadian Association of Internet Providers in 2004, Justice Binney, my old adversary, said, and I quote, "The word communicate is an ordinary English word that means to impart or transmit." This interpretation was followed by the Federal Court of Appeal in Canadian Wireless Telecommunication Association v. SOCAN in 2008, dealing with musical ringtones on cell phones. The dissent disagreed with the argument that the communication must be restricted to transmitting for immediate perceiving and listening like a performance. Under that argument, streams would be communications, but downloads which can't be accessed for perceiving and listening until the download is completed would not. But to the dissent, there was nothing in the definition of the word communicate to imply that the transmitted material must be perceived or heard immediately. And that is where the majority and the dissent disagreed. The dissent was of the view that the rights enumerated in Section 3.1 were each separate and distinct rights and not mere examples of the rights in the preamble of production, reproduction, performance, or publication, as suggested by the majority. The dissent said that you had to look at the listed rights in context. And, as I said earlier, that these listed rights were rights added by Parliament as they saw the need arise. Of course, the dissent had their view of the legislative history, which differed from that adopted by the majority. While there had been a relationship historically between the right of public performance and the right to communicate to the public, the legislation had evolved to take account of the evolution of technology. That was the reason that Parliament adopted the neutral language of telecommunication to cover all modern technology, even if Parliament could not foresee what it would be in the future. So there was no reason to exclude technologies that could include a communication occurring in a manner that would also provide a durable copy that a user may view at a later time. And indeed, this was recognized by Justice Binney in SOCAN v. Cape, where he said that at the end of the transmission, the end user had a musical work that he or she didn't have before. The work necessarily had been communicated. As he said, to hold otherwise would fly in the face of the ordinary use of the language. Well, in the result, the dissent was of the view that its interpretation was more faithful to the words of the Act and the precedents of the court. Concerns relating to whether copyright owners should be entitled to claim both the reproduction and communication rights were matters of policy, which were for Parliament and not the courts. Well, what I would call this more orthodox view did not prevail. So I come back to my original premise: judges don't like double dipping. When they see it or think they see it, they will want to preclude it if they think they can. That's what I traded on in my little altercation with Ian Binney almost 23 years ago in my freight rates case, and that's what ESA traded on in this case, and it worked both times. Well, one of the incantations that our judges recite when we are thinking about a decision is, do no harm. Some of you may think we honor that objective more in the breach than in the observance. In any event, we may be Supreme Court judges, but we are not prescient or clairvoyant. So we don't necessarily know the fallout from our decisions. Perhaps a respondent will make an in terrorem argument that will give us some idea of what effect the decision may have. But often, until things start to happen, we won't know what to expect. Well, what can be expected from the ESA decision? Will the finding that the enumerated rights in Section 3.1 are essentially just reflections of the words in the preamble mean that copyright will be read more narrowly now? Will technological neutrality become an overriding objective that may affect the balancing of copyright owners' and users' rights? Will Bill C-11 have any effect that is relevant to the ESA decision, or vice versa? The summary of Bill C-11 states, the enactment amends the Copyright Act to ensure that it remains technologically neutral. Well, the term technological neutrality does not appear in the bill itself, to my knowledge, but there is no doubt that there is an intention that this be an objective of that act. Well, I've read some blogs that have suggested that there may be big changes. I do know that earlier this month, Rogers, TELUS, Bell, Mobility, and Quebec Or filed a statement of claim in the federal court claiming unjust enrichment of some $15 million from SOCAN in respect of ringtones, which had been found to be communications by the Federal Court of Appeal in the CWTA v. SOCAN case in 2008. They say the ESA decision means that ringtones are not communications. Well, I won't speculate about that action for obvious reasons, but it is clearly one of the fallouts from the ESA decision. I do speculate that it may be only one of many. I'll move on to access copyright. The case involved teachers copying material from textbooks and other sources for students, and whether this copying fell within the fair dealing rights of users, and if so, whether the dealing was fair. Access copyright represented authors and publishers whose work was subject to copyright. The case considered photocopies of works by teachers for instruction in elementary and high school. If such copying constituted fair dealing, the copyright owners would not be entitled to compensation for that copying. The parties and the board had agreed that one of the purposes of the teacher's photocopying was research. So that satisfied the first step under the CCH test for fair dealing. The parties agreed that the appeal to our court should be decided solely on the second test under CCH. On the facts, was the copying fair, and thus did it constitute fair dealing? The focus was on the 6 factors or criteria set forth in that seminal CCH v. Law Society case. Purpose, character, amount of the dealing, the existence of any alternatives, the nature or character of the work, and the effect of the dealing on the work. While the 6 factors are not exhaustive, and some may be more or less relevant, depending on the circumstances, the majority at least treated the 6 factors, in my respectful view, as prescriptions to be specifically complied with, as if they were each statutory requirements. The majority found that the Copyright Board's decision was unreasonable in its application of the CCH factors, and I'll just take a couple of examples. First, the purpose of the dealing. The majority said it was unreasonable for the board to find that a teacher's purpose in copying was instruction as distinct from research or private study. They said the teacher's purpose and the student's purpose are, in their words, symbiotic. Research and private study, clearly fair in the fair dealing assessment. To the majority, the relevant purpose was that of the end user, the student, and the student's purpose was private study or research. The dissent considered the question of purpose on a more deferential basis, which it thought the reasonableness standard of review of a Copyright Board decision required. It considered the board's reasoning, which found that the predominant purpose was instruction and not private study. The predominance test ascribes a purpose both to the teacher and the student. While the student's purpose may be private study or research, the teacher's purpose is instruction. The dissent could see nothing unreasonable about a predominant purpose approach. The majority was of the view that the distinction made by the board between classroom study and private study was not appropriate. It said the focus should be on studying, not the geography of the classroom. The dissent said that the distinction was important. Private study couldn't mean hundreds of thousands of copies made across a province as part of an organized program of instruction. And that is what made the board's predominant purpose of instruction a reasonable conclusion for the board to have reached. Since the predominant purpose was instruction by the teacher, and the teacher was the one who was doing the copying, the predominant user in these circumstances was the teacher. The teacher's purpose weighed against fair dealing. As to the amount of the dealing, the majority said this was an assessment of the amount of the portion of the work copied, not the overall quantity of what was disseminated. The dissent agreed. The difference was that the majority assumed that teachers were only excerpting small amounts of a work, while the dissent relied on the board's finding that there could be numerous requests from the same work. The majority found the board's approach unreasonable. The dissent did not. About character of the dealing, the majority said the board had conflated the amount of the dealing with the character of the dealing. It said the board already considered the quantification of the dissemination under character of the dealing, and that it did the same thing under amount of the dealing, the total amount of the dissemination of the work. Well, but the dissent found that under the character of the dealing, the board had looked at the multiple copies of the same excerpt that were made at any one time to be distributed to a whole class, and this had been an independent finding from the portion of the work copied under the amount of the dealing criteria. Again, the majority was more intrusive, the dissent more deferential. Well, I won't burden you with any further distinctions between the majority and the dissent, but the net result was that the court remitted the matter for redetermination by the board. And the board did reconsider in what would appear to be a rather terse judgment written within the 2 months of the Supreme Court decision. It's a one-sentence decision, and I quote, "The decision of the Supreme Court is clear and leaves no room for interpretation. Based on the record before the board and the findings of fact of the Supreme Court, Category 4 copies constitute fair dealing for an allowable purpose and as such are non-compensable." I don't think the board's reference to findings of fact by the Supreme Court was inadvertent. I think the board considered the Supreme Court's findings to be too intrusive of what would be matters of fact and discretion normally left to the board. The dissent would agree. The purpose of the dealing was the major point of disagreement between the majority and the dissent. The majority had no difficulty going into the facts and reassessing the board's approach to the purpose test, at least in my view. The dissent found the majority approach inconsistent with precedent. CCH said whether something is fair is a question of fact. CCH criteria are not statutory requirements. Reasonableness review must be deferential if we are to respect the board's expertise implied by Parliament's assigning authority to the board on findings of fact and exercises of discretion. In access copyright, the difference between the majority and the dissent was in the intensity with which the court should review the tribunal's findings of fact and exercise of discretion. Our court, in other cases, piously intones that judicial reviewing courts must give deference to the tribunal whose decisions they are reviewing, especially on questions of fact and discretion. The dissent would say sometimes we don't practice what we preach. Access copyright and SOCAN v. Bell dealt with findings of fact and exercises of discretion by the Copyright Board. On the other hand, in Rogers, 8 judges agreed that the standard of judicial review of decisions on questions of law made by the Copyright Board are to be reviewed on a correctness standard. The court is to make its own determination of the correct law. And you may be right if you extrapolated that to the patent and trademark decisions by the Patent and Trademark Commissioners, because those statutes are similar to the Copyright Act in that they all confer concurrent original jurisdiction to both the tribunals and the court. That is quite different from the court's approach to standard of review on legal questions from other tribunals, where if the matter involves the interpretation of their home statute, their legal decisions will virtually always be reviewed on a deferential reasonableness standard. And I have to issue one caveat here. I said that you may be right if you think that what we said about the Copyright Act would apply to the Patent Act and the Trademarks Act in terms of standard of review of legal decisions. And of course, that hasn't been decided by our court. All I can say is that that will have to be decided, and certainly nothing I say today is intended to predetermine those questions. Well, as I said, the difference between the Copyright Board and other tribunals is that the courts, in the case of copyright law, have concurrent jurisdiction with the board. Well, here you had a review of a tariff decision by the board, but an infringement action would be brought directly to the court. And in both circumstances, the board and the court may be called upon to decide the same legal question involving the interpretation of the Copyright Act. In the circumstances, it can't be assumed that that the legislative intention was to recognize superior expertise in the board relative to the court with respect to such legal questions. So it would be inconsistent for the court judicially reviewing a legal decision of the board to do so on a deferential standard and decide the exact same question of law de novo if it arose in an infringement action in that court at first instance. Well, the reason I've taken a moment on standard review of legal questions, even though that wasn't the situation in access copyright, that was factual and deferential matters, but the reason I've taken a moment on standard review on legal questions is because it would appear that intellectual property practitioners who have appeals on questions of law from tribunals to the courts can expect the courts to get right to the merits of the legal question without getting sidetracked on the question of how much deference to accord tribunals' decisions. You might detect that while I agree with deferential review on questions of fact or exercises of discretion by tribunals, I am not an advocate of deferential review on legal questions decided by tribunals, any tribunals. And you would be right. But that is a matter for a different presentation and perhaps a different audience. Well, I'll conclude by telling you that as a Supreme Court judge, you get to have some really unique experiences. Last November, I was invited to judge a moot court between Sir Robin Jacob, recently retired as a judge of the English Court of Appeal, and Lord Hoffman, a recently retired judge of the then House of Lords. It was a patent case involving a coated stent for insertion in coronary arteries after angioplasty. Before he retired, Lord Hoffman in the House of Lords had reversed the decision of Lord Justice Jacob in the Court of Appeal. The two judges agreed to re-argue the case themselves at University College London, and they asked me to judge it. Both judges are highly respected intellectual property experts. When I received the invitation, I said to Sheila, "Did you ever think in your wildest dreams that I would be judging a moot court between two world icons of intellectual property law?" And Sheila said, "Marshall, you aren't in my wildest dreams." Thank you for your attention.
Thank you very much. I think we could both agree that it was entertaining and also educational. And I think we can also report back to Sheila that you did a wonderful job, and she should be very proud, right? We have to stick up for her.
She won't believe you.
So we now have some time for questions. I'm just looking at the watch. We have about 20 minutes. And so at this point, we welcome questions from you.
Easy questions, please.
So if there's 2 mics on either side, if you could just come up and ask your question. There. Okay.
Justice Rothstein, since nobody else wants to ask a question, I'll have an easy one to ask you just to start it off. And it's about the Bell and SOCAN case, about the determination that when assessing the purpose of a dealing, you look at it from the point of view of the end user rather than the provider. Did the court consider that that was consistent with CCH or a step beyond CCH? Certainly when you read CCH, you could look at that case as one where the court was striving to deal with a particular case where the Law Society was making copies on behalf of end users, but the court was still focusing on what the Law Society did. They didn't necessarily jump right to what the user was doing. So I was just wondering, was that something that the court perceived as an evolution in the analytical framework or as being simply the application of the framework?
Well, just speaking for myself, I didn't view it as any particular extension from CCH. As I recall, these are just my words, but in CCH, the Law Society was really acting as kind of an agent for the user, for the lawyer who's requesting the information. I'm sure everybody here knows that CCH was the case of the Law Society providing copies by fax to lawyers who requested copies of cases, and the Law Society was only doing that at the request of the user, and I didn't think that SOCAN v. Bell was really much different than what was decided in CCH. So I didn't view it as an extension, but well, I guess we'll wait and see whether that's right or not.
Justice Rothstein, I was struck by your comments from the outset about the aversion that judges have to double dipping. It seems pervasive anyway in the ESA decision, but one of the things that I thought was absent from that decision was what might have been a countervailing factor in this case, and that's the fact that there are significant cost and structural differences between the digital market for downloads of content and the physical market for purchases of physical copies, right? Obviously, in the physical market, there are costs like manufacturing and packaging and shipping and maintaining retail premises and so on and so forth that by and large are either significantly lower or absent completely from the digital market. And so another way of looking at the SOCAN case, I would have thought, is that rather than double dipping or layering rights, what you have are substitute costs, where the exercise of the communication right is in effect a substitute and a substitute cost for some of the tangible costs that appear in the physical world. And that doesn't show up, obviously, in the majority decision, and if I'm not mistaken, I don't know that it shows up in the dissenting opinion either. So I'm curious to know if you have any thoughts on that sort of dynamic.
Casey, I'm remembering that when trying to figure out how to deal with the case, I know that I spoke to my law clerk, and we chatted about it, and kind of knew that there were distinctions between the sale in the store and the sale over the internet. And we talked about differences in cost, differences in structure, and things like that. But my recollection was that it was going to become kind of complicated to get into those kinds of things. Now, I can't remember exactly what we had in terms of evidence on that. I can't remember now whether we actually had evidence of countervailing costs in different technologies or different modes, if you like. And my recollection is that we didn't, because I think had we seen evidence that was, or had I seen evidence that that assisted in making that kind of a balance argument of some sort, would have used it, but I don't recall that we had that kind of evidence.
I think it was before the board. I'm not sure. Well, I know it was before the board. I'm not sure that to what extent it showed up in oral argument before the court, but I know that that was a big factor in the Copyright Board's original decision in 2007.
Yeah, it just seemed a little bit difficult to deal with when we're dealing with a legal point. Just a little bit difficult to deal with, I must admit, when we were looking at trying to deal with a statutory interpretation argument.
Thank you.
Hello, hi, Justice Baston. My name is Charles Ajiman. I'm a student from University of London and a graduate student from Osgood Hall.
Could I get you to speak a little closer to the microphone?
Okay. Okay. I know Lord Hoffman, and I was into your question about, your assertion and interpretation of what you talk about. Judges' role in statutory interpretation, and you clearly stated that judges are bound by parliamentary intention and not to override it. And I just have a little bit, I'm puzzled about it, and I wanted to ask you, why do you think judges should be bound by parliamentary intention, even if those intentions, or when those intentions can be clearly declared to produce an evil outcome or some kind of injustice? And I will cite two cases here. Number one would be the Persons case, for instance, the Persons case in Canada. In 1924, Lord Sovinke decided that the BNA Act was a clause that declared or state that women were not, by definition, persons, was wrong, and it should be rectified, and women should be qualified as persons in the House of Commons. And the other case is about what's it called? Marlborough versus Queensland in Australia, where the Chief Justice declared that parliamentary intention with regards to land entitlement, that the government said that the native people shouldn't be entitled to their land, was wrong, and the historical injustice must be corrected. So I want you to help me, if you can shed some light on that parliamentary
Just let me make sure that I'm understanding your question. You're asking me about precedent and whether judges are bound by precedent, or if I missed this?
No, I'm just asking, why should judges, because I know that judges are independent, so I think they should not be bound by parliamentary intention. But if they are, why should they?
Not bound by parliamentary intention.
What do I mean by that? Like Peter Hogg once said that judges always try to achieve what's called an objective dialogue by interpreting what parliaments want to actually produce. And I'm asking Justice Baston, why should judges, including the Supreme Court judges, be bound by this notion of parliamentary intention?
Just bear with me. I want to make sure that I'm understanding the question. He's asking whether we should be searching for parliamentary intention. No, we should be Okay. You're asking me why we should be bound by parliamentary intention rather than doing the right thing?
Yes.
Yeah, okay. you know, you're asking a very good and a very difficult question. But we live in a democracy, and where we are dealing with statutes passed by Parliament or a legislature, they're passed by members of Parliament who are elected by, who are there by majority and make majority votes. It's for a single judge or 3 judges in a court of appeal, or even 9 judges in the Supreme Court of Canada, to disregard that what Parliament has said, because we think it may be unfair or inappropriate or not in keeping with the times, would be to usurp that function that in a democracy we leave to democratically elected people, and take it upon ourselves, a very small group of people, to impose what we think is right. So that's my explanation for why we feel bound by parliamentary intention as best as we can figure out what it is. It's not to say that we don't look at Parliament's intention and can't interpret it in a way that is consistent with that intention, but may be consistent with more modern times, but still it's got to be consistent with that parliamentary intention. Otherwise, we just have a rule of 9 judges, if it's the Supreme Court, and we're not adhering really to the rule of law. It just, some people say, the rule of men, or rule of men and women, not the rule of law, which is fundamental. So I think that that's the reason that I would give you for trying to figure out what Parliament's intention was, and then trying to adhere to it.
Okay, thank you.
Maybe I should just add one final caveat, and that is this. The one place where we have to depart from that, I think, is when we are dealing with Section 1 of the Charter. In the case of Section 1 of the Charter, where we find that a law is inconsistent with the Charter, we have to decide whether it still should be preserved in a free and democratic society. And then the 9 judges, if it comes to the Supreme Court, have to make that decision. And it's a difficult, that's one of the most difficult parts of our job, because we have to be very careful that we're trying to be as objective as we can in making that decision. But that's one place where even if Parliament or a legislature's intention is quite clear, if it violates the Charter, then we have to decide whether that violation can stand or not.
Okay, thanks.
Hi, thank you. Okay, I have, well, one of my favorite questions to ask students in my copyright class in their exam, close your ears, students in my copyright class, is how they perceive the role and the relevance of this concept of balance that came out of the Baver case, and the way that it has played a role in the court's interpretation and application of the statute since the Baver ruling. And in particular, you know, we saw, of course, in CCH, it seemed to unify the court behind a broad and purposive interpretation of the fair dealing defense as a user's right. But then we saw, of course, in Robertson and in Kraft, that the minority judgments seem to pay greater attention to the idea of balance and its significance. Justice Bastarash, for example, in thinking about the appropriate role of copyright in a parallel importation scenario, or in Robertson in the dissent, focusing upon what would the analog equivalent be of the electronic database. And so what we see is that balance seems to be playing a different role in arriving at different interpretations of the statute. And so my question tends to try to get students to think about whether it has been helpful, whether it's appropriate as a guiding principle, and whether it does in fact guide, or whether it just provides some kind of rationalization for a decision that would otherwise have been reached. So I just would like your thoughts on whether it has been helpful either in the deliberations of the court or what you feel its appropriate role is.
You know, balancing is a very judgmental kind of thing for a court. You know, copyright law isn't the only place where balancing takes place. But in the context of balancing between users and providers, it sounds tautological, but it's very judgmental. Just for example, a case that you'll all be familiar with, Teva, the pharmaceutical case involving Viagra. Well, look, there are the innovator's rights, obviously, and there's the public right to disclosure. Now, to our court, it was pretty obvious in that case that the user's rights had been ignored, essentially ignored by Pfizer. And it was the requirement of the court to correct that, because Pfizer had not, I don't think I'm speaking out of school because the decision's out. Pfizer hadn't played by the rules. They hadn't given the kind of disclosure that is at the heart of the balance between the user's right and the public's right in that case, and the innovator's right. But these things are judged, I think, mostly on a case-by-case basis. It's very difficult to draw some kind of principle through this concept of balance that is going to be precedential or is going to apply to every case. And you have to kind of look at the facts of each case. I mean, the next patent case that comes along dealing with whether there was adequate disclosure or not, well, got to look at the facts of that case. You have to look at the patent and see what kind of disclosure there was and make an assessment of whether that was done. But you did kind of raise an interesting point. Maybe my words, maybe not your words, maybe I'm misunderstanding, but it's kind of like, is this balancing just kind of an after-the-fact justification for making a decision and trying to call it principled in some way? I don't know that I would go that far, but because I think the concept of balance is there. I mean, in all of these statutes, all the IP statutes certainly, or at least in copyright and patent, there's providers on one side and there's users or the public on the other side. And the legislation does seek to have a kind of recognize the rights of both. So, how else to do it but to talk about balancing? The one thing that probably is true is that since the Burge and in more recent times, there's been more emphasis on the balancing that perhaps there was years ago when maybe the focus was more heavily weighted toward the providers than towards the users or the public. So I think maybe in that sense there's been perhaps a bit of a shift, but still every case still has to be decided on its own facts.
The point that you raised about double dipping I found to be particularly interesting. Especially interesting given that, based on my understanding of the facts as they were before the board, the people least likely in the video game market to be the subject of that double dipping were the members of the association that brought the case because of the nature of the contracts they signed. Obviously, that fact didn't get through to the court. And I'm asking you, I suppose, the extent to which the tribunals below should be expected to anticipate the facts that may or may not trigger the interest of the reviewing courts of the Supreme Court of Canada, and therefore make an effort in accounting for those facts that may not be brought evidently as part of the record. And I'm afraid it brings to me the fear that the decisions of the tribunals below are going to have to become inordinately long in order to cover all angles and possibilities. There's certainly one point on which there is a perception that the wool was pulled over the court's eyes on that particular point.
Well, you're speaking to a dissenter. So.
I know.
What can I say? And also, don't talk to me about long decisions. I must say that as an appellate court, we rely very heavily on fact-finding by primary instance courts or any tribunal. And the more thorough those facts are, the better from our point of view. But you still can have cases where judges look and they say this case, the situation here is unreasonable. And you know, in ESA or in access copyright, you saw, you know, judges coming to that conclusion, and that's kind of the way they looked at it. And the same thing in ESA, but in access copyright in particular, they looked at it, and as I explained to you, in my view, they looked at it more intrusively than a reasonableness review would justify, but they didn't feel so. And reasonableness review doesn't mean that the tribunal is absolutely immune, that they've got immunity. So, you know, there's going to be cases where a court will say this is unreasonable, but all I can say is you're preaching to the converted. You can criticize me for not being persuasive enough to try and get another member of my court to go along.
Okay, so one last question, if you could make it very brief.
Okay. I know we come from a tradition, we used to have two courts. We had equity and we had common law, and now that we've merged, my question is, especially in copyright that is a creature of statute, what room is there for equity in interpretation and in judgments?
I want to be flippant and say not much. I would say that really we're bound by statute, and so we have to. We really have to deal with the statute and what the statute provides and what it doesn't provide. But I can't say that equity never, ever, ever would enter, just because there are probably some equitable doctrines, not within the concept of the Copyright Act, but otherwise that may apply. Now, I'm not suggesting that this could ever apply in a copyright case, but for example, the doctrine of laches, and I'm just mentioning that because I happen to be working on that right now in another matter. But this is an equitable concept. And where a statute of limitations may be found not to apply, perhaps you're faced with looking at this question of laches, and you know, that could enter even in a highly structured legal analysis, possibly. So I don't want to rule out the possibility that there couldn't be areas of equity that enter. I mean, there, you know, people dealing fraud. For example, now that you remind me, I think that in the U.S., good faith and fraud may be factors in a fair dealing analysis. So, you know, there you've kind of got some sort of equitable considerations that may enter into a copyright decision. Now, I don't know how we're going to develop our fair dealing analysis here, whether we're going to go outside of the 6 factors in CCH and look at others and so on. But if we do, we may pick up some equitable considerations along those lines. So yeah, there's some room, I guess, but it's not a free-for-all for equity in this case, I wouldn't think.
Okay, that's great. So this is the time to really say thank you to you for joining us today and for educating us. It's such an honor to actually be able to ask questions when you're the one grilling everyone else. So with that, and perhaps we welcome you back to reflect maybe a year or 2 from now and see the musings of these decisions and what happens after C11. Perhaps we digest that a bit more. So we look forward to seeing you here again. And just if you could all join me in saying a big, big thank you to Mr. Justice Marshall. And just a quick note that on the website, you should check it out, iposgood.ca, because there will be a recording of this event. Adam, who's sitting there, will be blogging on this, and you'll get to infuse more comments to today's event there. We have lots more events in store. On Thursday, actually, we have Justice Hughes, who's coming to speak. So much more in store. Also, a community is only as vibrant as its members, so we do encourage you to bring your ideas forward, your thoughts forward, your sponsorships forward, because it's also your support that makes such events possible, and we thank our sponsors and all the organizers. So look forward to hearing from you and seeing you at our next event.
Thank you.